Our topic for this morning is cybersecurity in the U.S. and the EU. So hopefully that's the topic you came to hear. My name is Tom Smedinghoff. I'm a partner with the Edwards Wildman law firm in the Chicago office. And today we'll be talking about a number of issues relating to a variety of different cybersecurity topics. But before we start, I'd like to go down the row here and ask our panelists to introduce themselves. Joe, you want to start?
So my name is Joseph DeMarco. I'm a partner in the law firm of DeVore and DeMarco, which is based in New York. It's a small boutique law firm focusing on areas of cybersecurity, cybercrime prevention and response. Prior to starting the firm for 10 years, I ran the cybercrime unit at the Department of Justice in New York, the U.S. Attorney's Office for the Southern District of New York, and that was from 1997 until 2007.
Excuse me. My name is Francoise Gilbert. My office is about 2 miles away, and my house is about 2 miles away, so I'm really local. And I'm the managing director of the IT Law Group. We are a boutique specializing in information privacy and information security, nationally and internationally. So that I'm the one with the foreign accent.
So I do have the foreign accent, but a different foreign accent, and I'm the token non-lawyer in the whole conference, I think. I'm Johnathan. I'm the CEO of Tal Global. We are an investigative and security consulting firm. And prior to things going to litigation, we get called by clients saying, someone breached us, someone stole up, crown jewels, someone is threatening us, someone is putting in some ransomware. So we do the investigation. We bring it to these folks on all my sides and to law enforcement. So we work both on the criminal and the civil side for basically all your clients and trying to keep people on the straight and narrow.
My name is Don Vieira. I work for the boutique law firm of Wilson, Sonsinit, Goodrich, and Rosati. I'm a partner in the DC office, and I specialize in government investigations and data and cybersecurity issues for the firm. I joined the firm about 3 years ago from the Justice Department. I was the chief of staff of the National Security Division there and worked on a lot of the governmental side of cyber intrusions and the related issues that flow from that.
Okay, we did actually have one other panelist, but due to a last-minute conflict, he was unable to participate. So I'm going to sort of maybe fill in a little bit of his slot and kind of kick things off with a couple of general comments about security law in the U.S. And I think if you step back and kind of look at it from the 100,000-foot perspective, I think we're in a situation where law in the U.S., from a variety of different sources, obligates businesses and other organizations to provide quote-unquote reasonable security. And a lot of the regulations and many of the laws say nothing more than that, reasonable security or appropriate security, which I think is kind of a recognition that security is relative. It varies from case to case, and what's required in one situation is different than what's required in another situation. But of course, that means for businesses, the struggle is what exactly do you have to do to satisfy your legal requirements? And the FTC has been particularly active over the past 12 years, I think if my count is correct, in enforcing security requirements against businesses under its authority through Section 5 of the FTC Act. And in particular, Section 5, which prohibits both deceptive trade practices and unfair business practices. And the FTC has used either or both of those prongs, but in particular, of late, they've been focused on bringing enforcement actions against businesses for violation, for failure to provide reasonable security in violation of their of the prohibition against unfair business practices. So in essence, the FTC has been saying failure to provide reasonable security is an unfair business practice. And they have brought numerous enforcement actions against many very large companies, household names like Microsoft, Facebook, Eli Lilly, and so forth, all of whom have settled and entered into 20-year consent decrees. And then about a year and a half, 2 years ago, Wyndham Hotels had a series of, I think it was multiple security breaches, and the FTC started investigating and ultimately brought another enforcement action, this time against Wyndham Hotels, for failure to provide reasonable security, alleging that was an unfair business practice. But unlike all of the other enforcement actions, Wyndham Hotels said, wait a minute, what's reasonable? You haven't issued any rules or any regulations outlining the requirements for reasonable security. In effect, this is a failure of due process here. You haven't told us what we're obligated to do. You haven't told us what rules we're being measured against. And so they challenged the FTC's authority, really, to bring any action under Section 5, but also challenged the FTC for failing to issue regulations to inform people what reasonable security requires. Now, we finally have a decision out of the district court in that case, where the court basically said, yes, the FTC does have authority to regulate security under Section 5 of the FTC Act, but more importantly, the FTC is not required to issue regulations in advance of its enforcement actions that businesses somehow have to figure out for themselves how that reasonableness standard applies to them. And to me, one of the more interesting parts of the opinion, the court basically says, look to past FTC decisions. Look to see how they've treated this in the past, and that you can use as guidance for how you're going to be treated and what your obligation is likely to be. And I think that's one of the key challenges that we're facing here is how does a business know what's reasonable security? And I'll throw it open to the panel for their thoughts on that subject. But in the paper that I submitted for the conference here, it's sort of an updated version of a prior paper I'd done on the subject, where I kind of look at that issue and try to work through, well, what is reasonable security? And from my perspective, it kind of comes down to adopting this written information security program, the concept that's outlined in some of the financial and healthcare regulations and is also outlined in the Massachusetts regulations, among other places. But let me throw it open to the panel and get anybody's thoughts in terms of, how is a business supposed to know what is reasonable security in light of Wyndham? Any thoughts?
So I typically, I'm being asked by clients on this all the time, what should we do? And, Fort Knox is one, and even that's breachable. So I give the tail of the lion and the two antelopes, and basically you do not need to be the World Cup of antelope. You just need to be a little bit faster than the other antelope running away from the lion. And you need to be just a little bit better than your competitors so that you, from a practical standpoint, you are less vulnerable, you are harder target, and you survive. I think that also works in the legal schemes because you can prove that you have done your due diligence, you've done what you needed to do, and a little bit more.
Well, I'm going to do a commercial here. Amongst my activities, I'm the General Counsel of the Cloud Security Alliance. And I want to invite you to go to the website of the Cloud Security Alliance. And there is a huge document which is called the Cloud Control Matrix. Cloud Control Matrix. So when you do a search, just Cloud Security Alliance Cloud Control Matrix, and it will take you to that page. And it provides you a huge Excel spreadsheet that compares the requirements of the different applicable laws or regulations or best practices, the PCI DSS, the HIPAA, FISMA, and so on. So you won't be able to see it on one single screen, even on my IMAX theater at the office. I can't put it there. But if you scroll, you're going to be able to see something. And I think it's a very useful document because it shows you the different languages used by the different statutes for the same purpose. So that's my commercial.
And from that chart, do you come to the conclusion that they're all using different words to say the same thing, or do you conclude that they're all these rules and regulations are saying different things and it's a real mess?
Well, I'm not providing legal advice today, but my view of the world is, first of all, it depends, of course, on the client you have, but it's very educational. It allows you to figure out that when some company talks about EPHI and some other one talks about personal identifiable information, in a way they are talking about the same thing as far as the type of access control or whatever it is that they are requiring. And so that allows you to figure out what is reasonable, because you can see that, well, for that particular concept of access, I see that 80% of the laws require something, therefore that makes sense. I think each of us can tell a different story on your interface with that matrix, but I think it's a very useful tool. Of course, it's free, so
It's always the most important part.
it's always the most important.
Do you want to, Joe?
From my vantage point, I would agree with everything that's been said already. You know, I think, you know, when I first read the briefs in the Wyndham case, I was very, very impressed with the briefs of the hotel and its allies on the amicus side. But I also knew kind of what I thought was going to be the court's answer. And I wasn't surprised, frankly. I mean, I was a federal prosecutor for 10 years, and I wasn't surprised that the FTC was reluctant to lay down or disclose in any fixed, meaningful format what it views as reasonable security standards are. By the same token, nor am I surprised that, you know, federal prosecutors will never tell you what the definition of insider trading is, right? Because once they tell you what the definition of insider trading is, they've told you how to engage in trading that will, bring you enormous amount of profits outside of normal standard channels. So you're never going to get a criminal prosecutor to tell you what insider trading is. You're never going to get them to describe to you the difference between tax avoidance, which is legal, and tax evasion, which is criminal. And so it wasn't really surprising to me, and I do think it does leave companies in a bit of a bind. That said, and I'll come back to this a little bit later when we talk about mental models, I think that you can and must do the kind of detailed analysis that Francoise is talking about, but I also think kind of sitting on top of that is an analytical framework, which I think many of the people in the room already know, but maybe some of your clients or business colleagues don't, which is to really just kind of think of the client's needs as it relates to, broadly speaking, what industry they're in, what data they transact and hold and maintain, and what their risk profile is, right? And at one end of the spectrum, you're going to have defense contractors, major hospitals, and other types of entities like that. At the other end of the spectrum, you're going to have, the digital equivalent of corner candy stores, right? Mm-hmm. So if you look at, kind of what the sector that they're in, is it highly regulated? Is it one with specific controls? If you look at the kind of data that they normally traffic in, and if you look at their risk profile, I think those are the kind of things that the regulators want you to be thinking about in broad brushstrokes, and then naturally apply the specific and articulate standards that may apply depending on how those three things shake out.
Well, Don, let's turn to a related issue. Last February, NIST released its cybersecurity framework. Can you kind of give us a little background on what that's all about and how it might fit into this whole process?
Sure. So some folks might recall at the beginning of last year, President Obama's State of the Union address, he mentioned he was going to take on cybersecurity. He put it up as a prominent issue, and shortly thereafter, in February of 2013, he issued an executive order, which called for a variety of things, among them calling for the Department of Commerce's NIST, which is the National Institute of Standards and Technology. It's not an evil guy in a comic book, but that's what it sounds like, to put forth and establish a framework for cybersecurity. The framework was explicitly to be voluntary. It could not be a regulation. And the executive order required that NIST consult with the private industry in putting together the framework. A year later, they've done that. They issued it in February of 2014, this year. The framework is just that. It's a framework. It is essentially a model for risk analysis and risk assessment for companies and evaluating the risks that they face from cybersecurity threats and the processes and procedures in place they have to mitigate that risk. By NIST standards, it's brief. It's only 40 pages. And it's actually written in language that is intended to be accessible to folks in the C-suite. So people who don't normally read sort of technical bulletins and things like that. This is really a document intended for them to understand and begin evaluating what the corporation or the organization is doing to deal with this, the threat from cybersecurity incidents. I can get into a lot of detail, which probably unnecessary here, but bottom line is it has essentially set forth a process for evaluating what the company is doing. It doesn't actually establish new standards in the sense that it references best practices, it references other standards that are already out there, but it doesn't create new ones. Maybe we should open up for the panel, but one of the questions that has come up from many practitioners is whether it will essentially become a requirement, certainly for folks in what's considered the critical infrastructure industries, which are a broad range of industries, to have at least gone through the process and evaluated each company's risks and determined where they fit in within the risk analysis set forth in the framework, and then set forth their own priorities and then live by those priorities by setting forth resources and related investment to get to the place where they need to be. So I don't know if that answers.
So if I'm a widget manufacturer having nothing to do with any critical infrastructure business, should I care about this? Is this going to set a standard that I might be held to if I do have a security breach down the road and I'm sued? And I mean, should I be worried about that? Joe?
I mean, I frankly think that if you have any business of any size or magnitude that traffics in any kind of personal identifiable information, including employee information, you would be well advised to look at the NIST standard. And the nice thing about it is it does scale to the nature, size, complexity, and threat matrix of your business. So naturally, you don't have to go through the framework if you're a widget maker in the same way that General Dynamics does. But to answer your question, Don, I think that it will become a de facto standard of care. Look, the counter argument is this, right? The counter argument is if you're, let's say you're a $10 million a year chair maker in industrial San Francisco, and you're just making chairs, and you have 100 or 200 employees, and you have 100 or 200 clients and customers. What you would have to say if you lost, let's say, a critical backup tape is that the NIST standard is so out there, is so funky, is so new, is so cutting edge that you could have never been expected even to just kind of take a passing look at it as it related to how you secured data. And I just don't think in today's modern litigation environment, that's a really tenable position. I'm not saying you wouldn't win at trial, but as we all know, negligence questions are often questions of fact. They're not necessarily questions of law. So I think unless you're a really small business, you have to at least, if you're a business of any size or scale, you actually have to at least pay attention to it and really just think about it as you think about privacy and security at your business.
Well, I think it's a great communication tool. Even just that is very important, because when you are preparing, let's say, an RFP for a client, you need to be able to explain what you do, how you do it. And this is, from the viewpoint of the company preparing the proposal, you have a great structure that allows you to ask all of your entities making the proposal to respond in a certain way, in a structured way. If you are yourself making the proposal, you can organize your proposal in that way and hope that the potential client is already familiar with that, and you will have a better way to communicate. It's a very good tool to communicate in case of litigation, again, to show that you have done your homework. because security is not just having a neat-looking private security program. It's also having followed a number of steps as required in Massachusetts, but as is generally expected from any litigator, state attorney general or government litigator. They want to see you that you have done your homework. And I think this NIST document is a nice, organized, simple way to get there. So it's even better for the smaller widget manufacturer than for GE or Facebook, because they already have that.
It does strike me the basic 5 categories of identify, protect, detect, respond, and recover. And those are terms that are so simple even a lawyer or a CEO can understand, right? I mean, to me, it really has a big impact there. But Johnathan, I'm curious from your perspective, in the kind of work you do, does that document appear to be relevant? Is it coming up, or how are you seeing?
So we got Francoise and Larry and I worked on a client that was actually interested in implementing it. And I think the beauty of NIST is that it's simple, it's inexpensive, you don't need to go through, it doesn't need to be an expensive process, and it gives you a way to self-evaluate and to give yourself an inventory. Even a smaller business than $10 million chair manufacturer can do this, and that you can do it internally or you can do it inexpensively externally, and you have a basis. And up until now, we haven't seen, smaller clients looking into establishing a security basis infrastructure. So we like it. It's good.
So has the administration and NIST sort of done an end run around Congress, which has been so dysfunctional for the last, 10, 12 years in terms of security legislation, and in effect created a law here?
Well, to touch on that, I think there's the potential for that to happen. The actual executive order that required the NIST's framework actually also contemplates potentially additional regulations. It says that it will take those under advisement if these other voluntary frameworks are insufficient. I think that's a shot across the bow to Congress and to the private sector to really take these things seriously. So that said, they did go to great pains, and this was in large part the result of prodding from private industry to say that this is a voluntary standard. They're not actually setting forth a legal standard in the sense of by laying out different levels of cybersecurity and giving them different sort of names and creating a new lexicon. They're not trying to establish new legal standards. I think the practical impact is sort of yet to be determined. I do think, and this goes back actually both to the Wyndham case discussion as well, it's both a process-based discussion and a substance-based discussion when you're talking about reasonableness. So one of the things the NIST framework does is it gives you that process. If you're a company, and this is something John was talking about, what are you doing just to make sure you have a security protocol? And is it not just at the IT department? Because it has to be one based on sort of technological best practices, but it has to also be a decision at the C-suite as to what you're going to implement, what are your legal obligations, and what risk are you willing to assume in putting together a program. And I think the framework is actually helpful in doing that. And for mature companies, I do think it could be quite a shield, frankly, against allegations that you didn't satisfy your duty, because here you have a government body ordered by the president to set forth a standard. You've gone through your process pursuant to that standard. It's relatively simple to do that. And I think many mature companies with mature security systems will find that they'll fare well under the standard. So.
Yeah, I think that's a great point, and I agree completely. I think it's a much more effective shield if you're a civil litigant fighting a civil lawsuit than if you're a civil litigant fighting an FTC or New York AG regulatory action, right? Because then, as we know from the Wyndham case, right, we're going to go look at the consent decrees, all the different things that people, pled guilty to for poor security practices, and if you did any one of those, it doesn't really matter much that you followed the NIST framework. In the eyes of the regulator, they'll say, well, that's really nice. It's wonderful you followed the NIST framework. Now let's talk about a fine. So.
There is that side of it.
But you must have done step one, which is evaluate your risk before writing whatever is reasonable.
Yep.
To me, this whole focus on risk, I think, is the key part, and I think that's lacking in a lot of security programs that companies implement. We'll turn to another topic now, but I just want to mention, if anybody has any questions as we're going along, feel free to step up to the microphones, and then we'll be happy to recognize you as we're going. But so we've been talking a little bit about U.S. security. Let's kind of compare the U.S. to the EU, if I can get the words out, and ask Francoise to kind of give us an overview of how the two ends of the world, if you will, approach data security.
Sure. Yes, and at this point, the U.S. as we've seen is not very clear about what needs to be done, and the EU is just a little tad clearer, but not that much. At the directive level, so at the state level, there is much more. So at the directive level, the EU Data Protection Directive, you have a general requirement under Article 17 that companies have appropriate security measures, that if they hire a subcontractor, that the subcontractor must be subject to a contract and be required itself to have these security measures. And that part you are probably familiar. It's somewhat similar to what is happening in the US. We have a law like this in California for certain categories of data. It's the common sense approach. You have data, you have to protect it, and you have to have your subcontractor protect it. The second part that is not as obvious for the American company is that this is part of the notifications. So I'm sure you've heard about the fact that currently when you are having operations in Europe, you need to report to each of the local data protection authorities in which you are operating. And so it of course varies from one country to the other. The disclosure of the type of security measures that you use is part of that notification. So don't think of notification only in terms of the pure privacy part, but there is also a security component, the security necessary to protect the data. And there you can have a very interesting surprises, let's say, where some countries are very interested in the detail of what you are doing. So in friendly countries, you're going to be done in half an hour. But in countries that are curious about what you do, you can have a lot of papers to fill out or to provide. So in some countries, you need to fill out a form and explain in their language what the security processes are. In other countries, you may have to provide even your actual security program. So that's something that is to be taken into account in your budgeting and other activities. The third part where we see security showing up in the current state of Europe data protection law is in connection with the transfer of data. So again, you've heard about data transfers and the restrictions to data transfers out of Europe. One of the criteria to examine whether the recipient of the data is worthy, is providing adequate protection, is with the security. And I've had actually to deal with data protection authorities on that particular question. So they were okay with the transfer of information, but at that time of providing us with the approval of the transfer, they wanted to know precisely what security measures we were going to offer in the US. So to summarize, three areas to watch: the Article 17 general requirement of security, the Article 19 in connection with notifications, and then the Article 25 in connection with transfer. Of course, I'm talking about the EU level. You know, of course, that each of the law is implemented in each of the countries. Therefore, you're going to have different implementation. I'll give you examples. Spain is very stringent. The UK is very friendly. France is very inquisitive. So you have a whole scope of personality. So that's the world today. And as you probably know or have heard about, the EU is preparing a major overhaul of this regime to move to a data protection regulation. the document, the final document does not exist. We are getting closer. There was a vote in March, but since then the parliament has been changed and a new set of MPs have been appointed. So it's all in the air. We're in the big fog until a whole new group of government employees, government agency management, MPs get their act together and start thinking about what to do next. If they do something, if something happens, let's say by January 1st of 2015, then we'll have 2 years until it's in effect. So right now we're talking about nothing happening before January 1st of 2017. So I'm not yet, I don't want you to be excited yet, but you should know that it's coming. So what's the major difference between the current regime and the future regime? In 3 words, less restrictions, less directive, something directed at you, less notification, so you're not going to not be notifying the Data Protection Authority. But on the other end, increased accountability and increased paperwork. So that means that we are going to have to write stuff like we just talked about to be able to satisfy this new requirement of more papers. More paper to show that you have one of this and one of that and policies and procedures and so on. The other difference is that because this regulation, if it is implemented as a regulation, which is not sure and might be implemented as a directive, which would change again the whole thing. But if it's implemented as a regulation, it will mean that it's one single law throughout Europe. And so because right now that's what we're working on, you have much more detail in this document, so in the future regulation than we have in the current directive. The current directive is very, very short. The regulation has pages and pages about you need one of this and one of that. You need to ensure that the data can be accessed only by authorized personnel. I mean, they give you really a whole list of obligations. So when you implement that, you will need to have your checklist. Okay, do I satisfy this one and do I satisfy this one? Other new components that we actually just talked about, the new regulation will require a data protection impact assessment. So something in a way close to the NIST framework.
Is that the risk assessment concept?
Yeah, it's a risk assessment concept. So they call that an impact assessment. Other changes, in the regulation, every company above a certain size will have to have a data protection officer, and that data protection officer will be tasked with supervising also the security matters. So that's about all from a legal standpoint. You should also be aware that there is a directive pending on a related topic. It's called the Network and Information Security Directive. That directive addresses, it's like a CERT, the CERT. It addresses the concept of sharing information about cyber attacks. So it's related to security, but it's not a requirement to have a security program. It's a requirement to disclose to the authorities that something has happened. At this point, there are 42,000 companies that are affected by that. But it's only a directive, it's not yet implemented. But it is something to watch. And that directive overlaps a little, but is different from our concept of security breach disclosure. The security breach disclosure is fully in the upcoming regulation. So now that I have confused you totally.
Well, let me ask you this. Is it fair to say that the focus in the EU, sort of unlike our focus on process and reasonableness, is it fair to say the focus in the EU is more on like you say, kind of checking the boxes, you have to have a firewall, you have to do this, you have to do that kind of approach, or are they more closely aligned?
Well, I think they are closely aligned. The change from the 1995 directive to the new regulation, to me, is a lot of it is the result of the fact that they are aware that technology changes, and so they don't want to have to tell you all the time, this is what you have to do. But so we change from a regime of notification, so, here it is, Mr. Agency, here are my papers, to a regime of accountability. So that's the most important part. You have to be accountable. You are responsible, and we want you to treat the data like responsible people. And then, as part of your accountability, here are things that you should be doing to be accountable. But it's a concept of accountability.
But is it still a situation of how you get there is up to you, as long as you address the given topic?
Yeah, it's sort of that. So.
Got a question?
Oh, I'm sorry.
Last week I was in Washington, and they're negotiating the new safe harbor. The Justice Commissioner was there, and there are two basic issues which are sticking points. This is the ITC administers the program, and I don't think they're close to a resolution yet. I think that's where the rubber hits the road.
Did you repeat the question?
Yeah, the question was the comment was about the safe harbor and the current negotiations between the U.S. administration and the EU administration. So it's a bit not, it's sideways from this, but it's related. As you all know, there are restrictions for the transfer of data outside of Europe to anywhere in the world. And the basic concept is, if your country does not offer adequate protection, you have to jump through hoops so that before you can transfer information, you have to sign contracts and so on. And the US, back in 2000 or end of the 1990s years, negotiated a special agreement with the EU called the Safe Harbor Agreement. Now we have 4,000, 5,000 companies who have registered, self-certified with the Safe Harbor in order to meet these requirements of providing adequate privacy protection. The problem is that the EU is not happy with this and has been threatening for many years, I would say, I don't know, maybe 7 out of the 10 years that it has been in existence, has been threatening to cancel the agreement because it is complaining that companies don't respect the agreement, that they fill out a form and that said they are happy to pay their $200, but they don't actually have measures. And so there is a very strong push from many angles from Europe to renegotiate. So, of course, the threat is we are going to cancel it. But the actual is they are trying to renegotiate something better, more stringent, stronger with the concept of the safe harbor. And so there is a deadline of somewhere during this summer. Mrs. Redding has really pounded her fist on the table and said, you guys are not behaving, and I give you until the end of the summer to shape up, and if you don't shape up, I'm going to kill the safe harbor. So that's where we are, and that's what this gentleman was referring to. And it's a tough situation. Yes?
Yes. Talking about the draft Cybersecurity Directive, I know that some people hold this up as the model of the world should follow. Others say it's an area that's already over-regulated, and actually the EU should be adopting more of a voluntary regime like this is proposed. I just wondered what your views were on that.
I have to repeat the question.
Right. I'm sorry, yeah.
The question is centered on the Cybersecurity Directive. Do you mean the Network and Information Security Directive? And the person is saying that there is a number of people who disagree with that directive because they feel that it contradicts other initiatives. I mean, there are many other documents that are in existence that supplement that, and there is a joint communication to the EU Parliament on cybersecurity strategy and so on. It's difficult to say this one is better than that one. I mean, all I care as a lawyer is give me one, give me one that I can follow, whether it's in the form of this or in the form of that. It really doesn't matter, because ultimately, as you say, the principles, the security principles are common sense. I'm sorry to say that, but it's common sense.
Sure.
Yeah.
And then whether you call it, HEPA security, blah, blah, or FISMA, they're trying to achieve the same thing. And in terms of the disclosures, that's the same thing. We are trying to help each other, let other companies know that there was an attack here, and therefore you should pay attention to this or that. So for me, that's what I'm trying to achieve with my companies. I want them to be there. Document whatever it is, doesn't matter.
Okay, let's, we've talked a little bit about a couple of different views on the legal side of cybersecurity. Let's talk about a little bit more of an esoteric issue in terms of mental models for cybersecurity and how that affects what we're doing here. And with that, I'm going to turn it over to Joe to kind of explain what we're talking about here and how that plays in.
Sure, thanks. But let me start by answering your question. My own personal preference would be for a model closer to the NIST model. That's not to say that the European model won't work better for the Europeans, but in terms of what I think works best in the context of the way United States businesses operate and organize their affairs, I think the NIST model is much more in harmony with that than a European model. But again, I'm not saying that the European model doesn't work well for the Europeans. So we've been talking a little bit about some of the more detailed aspects of cybersecurity, and at one end of the spectrum, right? This is about questions like, what is your encryption standard? Tell me about your two-factor authentication for remote access. Tell me about network permissioning. All the very detailed kind of nitty-gritty questions that can and must get answered at any kind of cybersecurity evaluation. I'm going to skip to the stratospheric opposite end of that pole. And that is to just kind of spend a few minutes talking about what I think are relevant questions fitting within the framework of mental models that I think all of us should be at least thinking about and probably talking about with our managers and our colleagues and the like. Because look, at the end of the day, we're all going to go back to our organizations. And maybe we'll have to meet with IT directors, maybe we'll have to meet with engineers, maybe we'll have to meet with people from information security, but we may also have to meet with managers who don't spend every day after Father's Day at the Stanford ECommerce Summit, right? They may be doing things like, I don't know, running a business and looking at opening plans and marketing and advertising and HR and labor. And they're going to say, well, all this is great, and you've come back with like these wonderful thought papers and all these different, you've given me 92 standards to choose from, but I have some very simple questions for you. And these are the questions that I get from CEOs and general counsels when I'm asked to do work with them, particularly in the proactive area. Not so much in the reactive area where you're busy putting out the fire, but in the proactive area. And the questions are questions like, well, look, I read the papers. You've told me about the Wyndham case. You've told me about all these 72 standards that are out there. In this environment, I get the fact that any company can be hacked, any company can have its crown jewel IP stolen, and any company can be victimized and then sued by civil litigants or by regulators who think that we failed in this area. Are you telling me that if I pick whichever one of the 92 standards you want me to comply with, can you tell me that if I comply with this standard, I'm going to reduce that risk by 20% or 10% or 5% or 50%, right? Because that's the kind of question that a manager asks. That's the kind of question the CEO or a COO wants to ask. Before they spend money, allocate resources, they want to know what the ROI is going to be. And I would submit to you that the truthful answer to that question, it may not be an easy answer, but the truthful answer to that question is, I'm sorry, Mr. or Ms. CEO, I can't tell you that question. You're asking the wrong question. And you're asking the wrong question because your mental model, and don't say it this way, your mental model is defective. Your mental model is a mental model that comes out of risk assessment and risk clarification in the physical world or in the general business world, right? I mean, look, if we wanted to get a sense of what the risk of a death from a fire would be in this room, that's a really easy risk to get a handle on, right? We have, the number of people that can fit, egress points, sprinkler system, smoke alarms, flammability of the contents of the room. I would venture to say that a fire risk specialist could give you, down to like the 8th decimal point, the risk of any of us being injured or killed in a fire accident in this room quite easily. And I would submit to you, too, that good accountants, good business people could give you the same level of degree of risk precision when it comes to things like accounts receivable fraud or collectability or employee fraud or malfeasance and the like. But cyber is different, right? Cyber is different, as we all know, because the data is constantly moving around. It's coming into and out of the organization at the speed of light. Devices are coming on and coming off of the network every day. Partnerships are being arranged by which we have people accessing our networks and we accessing their networks. The bad guys are hiding behind layers and layers of anonymity. The malware is being developed at the speed of light. And I would submit to you that in that environment that we live in, it's about as different from fire safety in this room as you can get. And so what I think the truthful answer is, and the mental model that your manager should be thinking about, is first and foremost not asking that question, not asking, okay, if I give you the X dollars you want, you can tell me that I will reduce a risk of an FTC enforcement action by F%, but rather, look, what I can tell you is this. I can't answer that question. I can't tell you that the ROI spend is this. I can't tell you that our company or the companies like us should be spending X percentage of whatever budget on cybersecurity, but what I can tell you is this. Number one, you need to address this issue. You need to address this issue because of legal, business, and reputational risks. Number two, if you do what I'm telling you that you need to do, follow standard 92 or standard number 2, whatever it is, you will reduce risk, right? You will reduce risk. I mean, look, I was a prosecutor for 10 years. I picked through the wreckage of every data breach imaginable. Recurring themes do present themselves, right? And if you follow any one of the models that any of us would militate for, you are going to reduce risk. Not only are you going to reduce risk, but you're going to increase your ability to detect wrongdoing when it occurs and respond to it effectively, efficiently, and in a cost-effective manner. And finally, when the regulators come knocking, right, or the plaintiff's attorneys come a-calling, you will be able to answer them with satisfactory answers that are going to dramatically improve the odds of a good outcome. So no, I cannot tell you that if you follow this standard, you will reduce your risk by X%. Get rid of that model and get rid of anyone who tells you, particularly any service provider that tells you that they can comply with that model, and start thinking about it in a fundamentally different way. And I find, at least when I have that candid conversation with managers who don't spend their full time in this space, it takes a while for them, it takes a little bit of time for them to think about it, but then it actually relieves them of a lot of pressure. Because they understand that in the world we're living in, given all the things that I've mentioned, this isn't a game about like getting fire safety down to 0.006 versus 0.007. This is about more top-level strategies of how to run a business and comply with the laws in this developing area. So I would suggest to you, for a mental model, that's about as good a mental model as I personally have.
So then, Joe, when the manager has to make the decision of whether I spend $20,000 or $200,000, how do they make that call?
You know what? Here's the honest answer. The honest answer is that's what they get paid to do. Okay? As with any decision that a manager needs to make, there are going to be decisions where they really earn their pay, where they really earn their medal. And that's going to be a judgment that not only, they're not going to do it by flipping a coin, they're going to consult stakeholders, they're going to make intelligent assessments, they're going to do the risk assessments that we've spoken about, they're going to do it in a thoughtful way. But yeah, at the end of the day, I'm sorry, someone's going to need to make a judgment call.
But I have a shrink for your mental issue. It's the insurance company.
Sure, oh, that's exactly right. Yeah,
because
that's right.
that's the shrink you should be talking to.
Agreed.
Because when you go to your insurance company and you say, Mr. Insurance Company, insure me against the risk of blah, 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 security breach, they're going to do this mental analysis and come with numbers and decide of your premium. And in many circumstances, they are going to want to know what are you doing, what do you have, what you don't have, and so on. And so it's a very useful conversation to have when you want to evaluate the risk of this or the risk of that, to talk to the insurance companies and see how they perceive you and your operation as a security risk.
For years, we had an insurance guy on this panel. And he said, basically, do the best practices and follow the standards, and you'll be okay. Because he did not have anything that was quantified to the eighth decimal. I mean, it was, remember,
We'll get there eventually.
Calumet,
Yeah,
We'll get there.
It's tough if you like to work with numbers, huh?
I also think it's useful to just to bring up what they're spending, where else are they spending their money? You know, I mean, if you look at the expenditure on physical security, for example, you know, many companies, particularly larger companies, spend an enormous amount of money on securing the physical space. But not securing your virtual space is like putting 5 bolts on the front door and leaving the windows open. It just doesn't make much sense. But because IT security is a relatively new discipline for a lot of companies, they're just not thinking about it holistically. So, you know, when advising companies, where do I put these resources? It is a business decision. It's in part going to be informed, as you know, by counsel and by the IT specialists that are going to come in and tell you what the risks are, and what your legal requirements are, and everything above that, I try to tell my clients is a business decision. But there is that minimum investment. But at the end of the day, explaining to them and having them look and say, okay, how much should we spend for coffee for our employees this year? How much did we spend on, you know, for some more very mature companies, having bodyguards for senior officers of the company when they travel? And you compare that to, you know, the limited investment they might put in to ensuring that employees are patching, their employees are doing just the most basic elements of a security protocol. So that's, I think,
I
important.
want to take an issue with that.
Okay.
We had too much agreement here. So there's $46 billion spent in this country every year on cybersecurity.
Okay.
It's just misspent. It is not spent right, and it's not spent holistically, as you said. So I'm not entirely disagreeing,
Okay,
but
good.
I think there's a tremendous amount of money that's being spent. The breach, if I may take it from here, Tom, the breach numbers grows by 20%, and basically it is not effective. Okay, so the amount of money spent is enormous. Let me just ask the question: how many people here are internal to, you know, like Fred in Google? Just raise your hand. Okay, keep your hands up. How many of the rest of you advise companies, like the CEO, like you would be very grateful? Okay, you can put your hands down. So everyone here is in a position, just about everyone here is in a position to advise or give that business advice to a CEO. What would you say to the guy at Target who lost his job? What should he have done? Okay, and this is kind of the
Take it away, yeah.
I think the issue is in the room. I've been doing this in this forum for 10 years, and for the first 5 years, there were 12 people in the room. I counted about 120. Okay, it's a big issue. It's a huge issue. And they're not readily available solutions because it's a new industry, it's a new threat. The threat is evolving. So about 7 years ago, I was talking about the Russian business network. It's coming, it's evolving, it's going to use the cyberspace, the internet for crime. Guess what? It's here. And it's knocking on the doors, and it's doing things like spear phishing. It's targeting people specifically. And who knows what spear phishing is? Raise your hands. Okay, so for the rest of you, phishing is what you get every day. You know, I'm Wells Fargo. I want you to put on your credentials because we are reorganizing. So please put in your username, your password, your social security, everything else on this website, and you'll be okay. So that's the regular phishing. We see this. I think we pretty much immunized to this, at least in this room. You'll be amazed how many people still respond to that, but clearly that is yesterday's technique. Today, Tom, you'll get an email from Ian Ballon, and it will say, here is a clip of video of you from moderating the panel today. Thank you very much. By the way, click here, and you'll get the whole program and the whole clip. You click, you've been hacked. Okay, this is directed, and it's not just you who are going to get hacked. It's everyone in your organization, because it is your login credentials, it is your ability, your authority to get into wherever people want to get in. Social engineering. it's incredible. We just had one of your colleagues, Wilson Sonsinit, bring in a client who basically lost their crown jewels to social engineering in a very short period of time. So it's the convergence of cyber and physical. Mm-hmm. They don't stand on their own. They can't be their own thing. They have to be measured, and the spending needs to be not thinking of based on ROI, as Joe said, but on risk. You need to do the NIST, you need to do your standards, you need to figure out your risk, and you need to approach it like the antelope that wants to survive.
Thanks. I want to thank everybody for turning to the practical side of things here. And I'm at LinkedIn and was sort of on point when we had Dave Breach a couple of years ago, that most people in the room unfortunately will have heard about. And I thought that I'd just quickly share a couple of things that I've learned from a practical perspective. So the first thing that I would encourage you to realize if you have Breach, it's not going to be like anything you've ever experienced. The pressure and speed and scrutiny is only comparable maybe to like a really high pressure trial, and for me it was above that. So things that I tell people and things that we operated on, first, assume that there is no privilege. There's no privilege, right? You should communicate with all of your business people that anything that, you're going to be held accountable for everything you say and do. That helps enforce that people behave better. And in fact, you will be debating that privilege later on down the line when you deal with regulators, because you're going to need to show what you did, which goes to sort of the next point, which is what's something that's really important is actually the speed and quality of your decision making. So one thing you're going to be looking at is how fast did you move. I mean, going back to Target, I mean, they actually were relatively fast, but they're immediately criticized for not being fast enough. So you need to get very comfortable with the risk tolerance and moving fast. You're going to be asked to like look at every email that goes out, deal with every blog post, every decision that's being made. You're going to be asked to make tons of decisions. You just have to get ready and recognize that you're going to get some of them wrong. It's better to not be slow. Third point I would say is be proactive with regulators. Reach out to them, same sort of thing. They're going to be much more interested in what you did afterwards and how fast you reached out to them and what you did to inform than getting it wrong in the first place. And finally, is a point that came up here earlier about insurance that I think may have slipped by and people might not have realized. Get insurance. You can get insurance on this, right? There are specific cyber insurance policies on this that cover it. They're actually relatively reasonably priced considering what the damages could be. So if you look at one practical thing you can do is you can get coverage for this, and it's something that you really should look into is E&O cyber insurance policies. And there was a discussion about maybe like getting feedback from them as to what to do in your program. That won't help. Probably they won't know. But at the same time, you're going to be better off having something because the numbers can really stack up, and you're going to look a lot better if you had 30, 40, $50 million of coverage at a reasonable price than, oh well, everybody else got hit and we didn't have anything.
I disagree with one point. I agree that speed is a critical issue, and that Target was in fact criticized for being too slow. There have been situations where companies have been too quick, and it's caused them problems as well. We have a question in the back there.
So you didn't have it for the page, but I've added for it. It goes beyond that, right?
Yeah, I was going to say, the focus is on insurance, and the question is whether it's good, bad, or indifferent. And I know from the perspective of a number of clients I've dealt with, it comes down to who's going to pay for this. And if we've got insurance, that's a big help, although I had one case where the client thought he had insurance and it covered all of $25,000, which was, hardly worth anything. Johnathan,
follow
go
up
ahead.
on the Target issue, because Target actually, the breach actually occurred around Thanksgiving. They did not make the notification until December 15th. Okay, it's a long time. They knew about it. They didn't pay attention to it, but they knew about it because they had FireEye. There was some notification going through. This breach was interesting for another reason. It was a breach that occurred at a mechanical HVAC vendor originally, and they wormed their way back into the Target servers. And it brings us to the requirements which we do have in the physical security world to check on your extended ecology. You need to make sure that you have your vendors, your subcontractors, your other partners in your process who have access to your information, who are inside under your umbrella. You need to make sure you do the risk assessment, NIST or otherwise, and you need to enforce the same standards, because otherwise you're just as vulnerable as the weakest link, which the Target case proved beyond a reasonable doubt.
Okay, Don, one last comment?
Yeah, and we're just dealing with one element here, really, which is a response, which is a critical element. But one thing I will say is that, well, you have to plan for your response to be effective. I'm so often my firm is brought in, and relatively sophisticated companies haven't really thought through who's going to make the decisions. There are so many key decisions that have to be made very, very quickly. Who's going to make the decisions? How are those decisions going to be centralized? What responsibilities are going to be distributed? As a lawyer, you may have a constant drumbeat of questions that are non-legal in nature, and you're going to have to farm those out, but you're going to have really important legal questions. Do you have responsibilities to inform third parties, for example, about what's happening? And that can be a very difficult job. And at the end of the day, there has to be someone at a very high level of the company that's going to have to make very difficult decisions that are going to be controversial inside the company.
You got to drill it. It's not enough to have a plan. If you don't drill, it doesn't exist.
And just to go on to broaden this a little bit and to give you guys some practical advice, what are you going to say to the public, right? And who's going to make the decision? I dealt with a breach relatively recently where they had various people at the company who regularly blogged about their activities and what they were doing at the company. Is that person going to be allowed to say, working on a big breach right now? And if not, who's going to tell the person he can't do that or she can't do that, right? So that's a small issue. If you haven't thought it through, they can consume you when you're trying to deal with core questions like, what did they get, how did they get it, and what are we going to do about it? The other thing is, are you going to talk to the authorities or regulators or not? And if so, which ones? Because in the United States, there's about 55 people you can talk to, and when. And you're going to want to think about that in advance, think through the legal issues associated with the notification, and think about what your corporate culture is and whether you want to bring in certain law enforcement elements or not. Are you going to utilize third parties to assist you in doing the forensics or not? Because some companies there have their own internal capacity. Others, if they have their own people doing the forensic elements of this, they're leaving the rest of the network wide open because it's the same people. So these are things, and there's a lot of literature out there. It's not telling, I'm not inventing anything new for you guys to bring home, but I'm just urging you all to sort of think, if you're going to think about how do we deal with that particular piece, that you really can't wait. Because if you're trying to build the aircraft carrier while it's at sea, it will sink. And I've seen that over and over again with other companies. So bring that back and work on that and drill it and just that's probably the most important thing you could take back, frankly.
And with that, we're a little bit over time, so we will wrap it up at this point. I want to thank everyone, and please join me in thanking our panelists.